Yeah, it's good for us to respond to, so we don't. Yeah, box. Yeah, yeah, yeah. Right, right. Right, right. There's a little bit of discussion about college, like training and groups, but that's really, yeah, that's like, right, 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 right. Exactly, exactly. I know I took some language. But she doesn't need some work, but she's a little bit up there. Yeah, exactly. And doesn't share has a million stories about right, right.
Hello? Hello?
You're connected, ma'am. We're just waiting for everybody to rejoin us.
We're here.
Okay, good.
I'm going to get us back on. Thanks so much for coming back promptly. We're going to get started for our third panel in the order in which they will speak. Our panelists are Maurice Emslem, Program Director with the National Employment Law Project, Kate Walsh, Director of Housing Justice at the Sargent Shriver National Center on Poverty Law, Amy Hirsch, Managing Attorney at the North Philadelphia Law Center, and Mark Levin, Director of the Center for Effective Justice with the Texas Public Policy Foundation and Right on Crimes Policy Director. So, Mr. Emslem, let's begin.
Thank you, Sarah.
Microphone is not on. There we go.
There we go. Thank you, Chair. Layman Commissioners, I'm going to talk more about the impact of the criminal justice system on employment prospects of people with records and some of the model policies to address the issue, and hopefully try to get to some of the questions that came up in earlier panels. I'm going to skip through some of my slides to try to get to those questions. But before I begin, I'd like to respectfully raise a concern regarding the need to include additional voices of directly impacted people who have the lived experience and the policy experience in employment, housing, education, and other areas to contribute to the discussion today. It's my understanding that this concern was raised with the Commission in a letter provided by the formerly incarcerated convicted people and families movement, which is the national organization representing about 30 states groups that advocate to restore the rights of people with records. And I would just ask that the letter be included in the record to recognize the indispensable voices of people with records in these discussions. Just wanted to mention that for starters, if that's okay. So first, let's talk about the challenge. We haven't gotten too much into these bigger numbers, but you know, the challenge that's been created over decades of excessive reliance on tough on crime policies. We're now at the point where 1 in 3 adults in the U.S. has a background, a criminal record that can show up on a routine background check for employment. And we know also that 34% of all prime working age unemployed men are walking around with a record. Now I'm going to skip over, there's a bunch of slides that relate to some of the new data that's out there, but like I said, I want to get to some of the policy issues that were discussed earlier. So I want to start with the guidance, the EEOC's 2012 guidance, updated guidance that creates the standards under Title VII to regulate employers and the background check process. I know you all had a hearing previously where some of these issues were discussed, but I just want to emphasize that the guidance made a big difference. First, I want to mention that what it includes the basic factors that most employers probably already consider, but it's required under Title VII, given the disparate impact of background checks on people of color. That includes an analysis of the nature of the offense, the age of the offense, and evidence of rehabilitation. And that's really important because it comes down to a case-by-case analysis. The routine that we're still super familiar with, that folks with records have to deal with every day, is that there are these blanket restrictions against hiring people with records. And that's totally contrary to what Title VII is all about and what the EEOC guidance is all about. And we now have some good evidence from employer surveys that guidance and enforcement of the civil rights laws is making a difference in employer hiring policies. So as you see, before you flip back, 88% of employers report that they're complying with the guidance. That's a big increase from when the guidance was first issued. 78% of employers are conducting this individualized assessment, again, getting away from the blanket restrictions against hiring people with records. So I just want to put in a plug for the importance of the civil rights laws that are on the books that regulate these issues already. Next slide. And then there was a lot of discussion earlier about ban the box. So I just want to kind of give a little bit of the background on ban the box and address some of the issues, some of the questions that came up. First of all, just so you're aware, you know, this is a movement that began over a decade ago. It was initiated by an organization called All of Us or None, which is a membership organization formerly incarcerated folks. We're now at the point where 28 states, bipartisan, as you can see from the map, have embraced ban the box policies. 9 of them cover private employers, and many major cities also cover private employers as well. About 20% of the workforce is covered by a law that regulates private employers under this policy. And to be clear, ban the box is not about eliminating the background check. It's about waiting until later in the hiring process to conduct the inquiry. And it's also about those EEOC guidelines. Most of the ban-the-box policies, in a way it's a bit of a misnomer ban-the-box. You'll hear the term fair chance hiring used often as well. Most of these policies also incorporate the EEOC standards in an effort to get away from these blanket restrictions against hiring folks with records. So what we know about the research, let's talk about the studies that are out there on this issue. First of all, we know from experience in several states that ban-the-box is producing measurable increases in hiring of people with records. Just here in the district, since the law was enacted, 33% increase in folks with records being hired into district positions. North Carolina, 7-fold increase. The studies that have been mentioned, it's very important to take a close look at those studies. There've been a lot of discussion in the press, but not enough scrutiny of those studies. Just to be clear, the studies support the conclusion that ban-the-box improves hiring of people with records in general. Also support the conclusion that people of record disproportionately benefit from ban-the-box. So that's a myth that's out there, that the studies say most people of color don't benefit from ban-the-box. What the studies say is that young men of color, in one study they just looked at 21 to 22-year-olds, in another they looked at 24 to 35-year-olds, that young men of color without a college education are being discriminated against in the hiring process. They're being stigmatized, stereotyped as people with a record because of their race. That's what it comes down to. So we're talking about a finite population, a critical population, but a finite population of folks who already are having the hardest time finding work because of discrimination against them, because they're young African-American men. And that's what those studies come down to. So for us, it's all about enforcing the discrimination laws. They're documenting that employers are discriminating, they're stereotyping young men of color as criminals, which is discrimination under Title VII, plain and simple. And it's my understanding that Commissioner Lipnick from the EEOC testified to that effect at the last hearing. That's plain and simple. So again, it comes back to enforcing the civil rights laws. Next slide, please. Lastly, I want to talk about occupational licensing restrictions. That was a topic of conversation earlier. This is from a report that we put together based on the ABA Collateral Consequences Inventory. Just to point out a couple extra facts. About half of the state laws in the books have blanket felony restrictions. No matter the type of job you're applying for, any felony will deny you employment under the occupational licensing laws. About half the states don't consider evidence of rehabilitation in the process of screening you for when they screen for occupational licenses. So let me jump to a positive model.
You'll have to jump later to it because you're trying
okay, all right. I have some ideas about positive models, I think, which came up around how to fix this occupational licensing problem.
Thanks very much. Ms. Wall?
Good afternoon. Every year, more than 640,000 people, roughly equivalent to the population of the District of Columbia, leave state and federal prison. For many, a common question emerges: where will I sleep tonight? In a 2015 survey of the Ella Baker Center on Human Rights, nearly 4 out of 5 formerly incarcerated individuals reported that because of their criminal history, they were denied admission or deemed ineligible for housing. The risk of homelessness quadruples for men who've been incarcerated. Housing barriers for justice-involved individuals can also severely restrain their ability to reintegrate into society by exacerbating other collateral consequences, such as limited employment and their ability to reunite with their families. In that same Ella Baker Center's report, 2/3 of the formerly incarcerated reported living with their families as a means to reintegrate into the community. However, restrictions on where people with criminal records can live mean that many of them are living in the shadows, and they are threatening the housing of their loved ones as a result. Given the often limited employment prospects for people with criminal records, the need for a chance to live in federally subsidized housing is great. There are 3 major HUD housing programs: the Public Housing Program, the Project-Based Section 8 Program, and the Housing Choice Voucher Program. Contrary to popular belief, there are only 2 narrow mandatory restrictive bans related to criminal records and screening. Providers cannot admit someone who's been convicted of manufacturing methamphetamines in federally assisted housing, and they cannot admit an applicant who is on the lifetime sex offender registry. Beyond those narrow instances, however, PHAs and project owners have the discretion over their criminal records policies. Federal law allows them to reject individuals who've engaged in the following activities: violent criminal activity, drug-related criminal activity, or criminal activity that would affect the peaceful enjoyment of the premises by other residents. In 2011, then HUD Secretary Sean Donovan emphasized that this discretion granted to housing authorities and project owners should be used to give second chances to justice-involved individuals. Yet, in our 2015 report of the Shriver Center, When Discretion Means Denial, a national perspective on criminal records barriers to federally subsidized housing, we reviewed the criminal records policies of over 300 federally subsidized housing providers. And we found that for the most part, unfortunately, PHAs and subsidized housing owners were instead closing the door on applicants with criminal records through one of four means. First, they are denying people on the basis of a mere arrest. In one instance, one arrest in 7 years automatically denied admission. They are also not limiting the time period by which they look back. In some cases, they say the look back period is between 99 to 200 years. They are also using overbroad categories of criminal activity, including any conviction whatsoever, however minor or unrelated to the ability to be a good tenant. Finally, they are not considering any mitigation evidence, including the evidence of rehabilitation. We found similar practices in the private market. In fact, an Austin, Texas survey found that local housing providers had essentially adopted the same rules of thumb that subsidized housing providers have. Discrimination exists not only in the way admission policies are written, but also in how they are administered, as demonstrated by fair housing audits in Washington, D.C., New Orleans. In these audits, African-American and white testers attempted to apply for rental units with identical criminal histories and explanations for those histories. Both audits showed that landlords treated white testers more favorably than their African-American counterparts, portraying the criminal background check policy as flexible and forgiving for white testers, but an automatic denial for African-American testers. To help combat barriers for people with criminal records, HUD has taken two important steps. First, in late 2015, HUD issued PIH Notice 2015-19. This notice reminded project owners and PHAs of the procedural requirements and notice entitled to by applicants before they were denied admission due to their criminal records. The notice also importantly stated that using an arrest record was not a permissible basis to deny admission or to terminate their assistance. Then in April of 2016, HUD's Office of General Counsel issued important guidance that outlined the fair housing rights of people with criminal records. Although criminal records is not a protected class, the guidance clarified that a housing provider's criminal records policies may nonetheless give rise to a Fair Housing Act violation under the theories of intentional discrimination and disparate impact. A number of housing authorities have been taking important steps to reintegrate justice-involved individuals into their communities. For example, the New York City Housing Authority started its family reentry pilot, whose purpose is to reunite families leaving the criminal justice system with family members living in its housing. These pilots can provide important evidence on how opening a door to housing for the formerly incarcerated can also reduce recidivism rates. A pilot out of Pennsylvania showed the recidivism rates declined by more than 30% for program participants when compared to the recidivism rates for the county and the state. However, given that these PHAs only represent a handful of the more than 3,000 housing authorities around the country, more impactful change will require bold leadership from HUD. We commend the Commission for taking a close look at the issue of collateral consequences of a criminal record, particularly as it relates to housing. Although progress has been made, more must be done to ensure the millions of people across the country are not unfairly shut out of their housing that they may need to leave the criminal justice system behind them. We ask for a report from the Commission that highlights the need for housing for people with criminal records and the barriers they face, and to highlight as well some of the pilots that are being adopted around the country. Thank you.
Thanks very much, Ms. Walls. Ms. Hirsch?
Thank you very much. I work in legal services. I run the North Philadelphia office for community legal services, and I'm also the managing attorney for our public benefits units. We represent about 10,000 low-income residents of Philadelphia a year in individual civil matters, and a lot of our resources are spent on collateral consequences. Before I talk about the particular issue I want to discuss today, which is the denial of access to TANF and food stamps, particularly to women who have criminal records, I want to just briefly say in response to things that were raised this morning, that wherever possible, there should be systemic changes. There was a suggestion this morning that where we have the opportunity for case-by-case individual petitions for redress, legal services can handle those cases. We have a lot of work to do. We do not have enough lawyers. We do handle those cases. It's incredibly important that we handle those cases. We cannot possibly meet the demand. You could divert large sums of money to us and we could not meet the demand. It's really important as people think about these issues that you think wherever possible about systemic changes. So in 1996, as part of welfare reform, there was a little noticed piece of the federal statute that says that unless states affirmatively pass legislation, any individual with a felony drug conviction is banned for life from receiving TANF, which was the then new name for what used to be called AFDC, and from food stamps. The states, some states have acted to lift this lifetime ban. Some states have not. Many states have modified it in a trying to think of a more positive word than bizarre, with a tremendous range of variation. So there are states where you can't get benefits immediately upon release, but years later, you may be able to get benefits. There are states where you can get cash assistance, but not food stamps. There are states where you can get benefits while you're pregnant, but not after you have a child. There are states where you can get benefits after you complete drug treatment, but not while you're in drug treatment, which makes it really hard to stay in treatment because you have no source of food and no source of income. And the odds of successful completion of treatment go way down. I was lucky enough to take a year off from my caseload and to have a fellowship to do research and writing. And what I did was the first study that I've been able to find of women with felony drug convictions. Usually when people talk about women and drug usage, they focus on pregnancy, but there's relatively little actual data about women with felony drug convictions. The best estimate from the Sentencing Project is that there are 180,000 women who were hit with the lifetime ban between 1996 and 2011. I haven't seen a number since then. Because it's a lifetime ban, it continues to grow. The picture that I found, both with the women I interviewed, and I should say I also interviewed prosecutors, police officials, corrections officers, public health workers, a wide range of individuals working in the field, is that the way that women get drug convictions is because they have been physically or sexually abused. And in the absence of other resources, they have self-medicated their pain. There was a question raised this morning about provision of services after release versus provision of services while incarcerated. I want to make a pitch for provision of services before people hit the criminal justice system. So the women I interviewed uniformly had been sexually abused as children. They had heartbreaking stories of the abuse that they had experienced. They'd experienced domestic violence in dating relationships and marital relationships. They'd used drugs to dull that pain. And uniformly, the very first place anybody talked to them about the abuse they had experienced or offered them help with that abuse or with their addictions was in jail. And that's crazy. I mean, we should not wait until people are incarcerated to respond to domestic violence and abuse. And I want to just, in my remaining under 2 minutes, read you a couple of quotes because I think it's important to hear the words that they used. And I should tell you, I didn't explicitly ask about abuse. I just asked, tell me about your life. What happened? How did you end up here? So this is a quote from Lynette. My stepfather was drunk a lot. My mom left us alone with him. I was sexually molested by my stepfather. I was hurt because I told my mom and she said maybe I led him on. I was very young. They took me away when I was 13 and it was before then. It went on for a year or two. The drugs I used when things really hurted me so I wouldn't feel the hurt. From another woman. When I was a child, my father used to rape me. It started when I was 9. After I ran away, I wanted someone to want me. I ran into this guy. He was older. He gave me cocaine. I was 13. From a third woman. I was afraid to go to sleep at home because my mom's boyfriend came in and messed with me. I thought if I could just go to sleep. I only felt safe sleeping at school. So I went to sleep at school every day and they yelled at me. Another woman I interviewed told me that she was so pleased that she could take classes at the jail. And I said, what kind of classes? And I thought she was going to talk about GED, maybe, some other literacy related classes. And she said, well, they have a class about being raped in your home and they have a class about being raped on the street. And I needed both those classes. The idea that we would respond to those life experiences, to that kind of abuse, and to the addictions that resulted from that kind of abuse, with a law that says that you can never be good enough to get welfare. When you think about the level of stigmatization of welfare benefits in this country, and when you think about the degree to which that cuts you off from any part of civil society, to me is just appalling. Thank you.
Thanks very much, Mr. Levin.
Yes, thanks very much. I'm pleased to be here and hopefully I can add to some excellent testimony that we've already heard. Our focus at Right on Crime and the Texas Public Policy Foundation is first and foremost on employment and self-sufficiency for those people who either have a criminal record or are formerly incarcerated. And as you've already heard, the research is very strong that people who get a job, especially rapid attachment to work immediately after leaving prison, are far less likely to be reoffend as well as to be reincarcerated. We're also facing major demographic changes in the aging of our society, and we absolutely need to tap into the vitality of this large workforce. Just some of the data on that, 88% of probationers who are employed at the start of their supervision are successful. Only 37% who are unemployed at the start of their probation supervision are able to complete that without being revoked to incarceration. They're also, by the way, much more likely to complete their restitution obligations to victims of crime, which is very, very important. One of the solutions for addressing this is sealing old criminal records. And fortunately, there's been a great deal of research looking longitudinally at offending patterns and desistance. And what it has found is, this is research from the University of Maryland, University of South Carolina, but basically after 7 years, if someone's been living in the community without committing a new offense, they're no more likely to offend than someone who never had a brush with the law. And even after 5 years, the risk is about the same. So what that leads to is we really need to adopt policies that allow people to obtain a record of non-disclosure or record sealing. Now, in Texas and other states, that is different from an expunction or an expungement in a number of ways. Most importantly, that if your record is sealed or non-disclosed, the prosecutor, law enforcement, judges, they can still see it. It could still be used to enhance under repeat offender statute, so it's not a physical destruction of the record. Now, of course, For people that are exonerated, we absolutely should physically destroy the record. And there may be some role for that, I think, even for people, especially after 20 years, if somebody had a low-level drug possession, maybe we should expunge it. But certainly, more broadly, allowing people to seal those records. And there are also exceptions in our law in Texas and other states for certain licensing boards that could still see some sealed records from some occupations that are, involve potential danger to public safety and so forth. So one of the other states that's moved forward on this is actually Indiana. When now Vice President Pence was governor, they adopted a record sealing law, Act 1482 in 2013, that was really excellent. And then currently pending, there's something called the Clean Slate proposal in Pennsylvania, which makes a significant advance, I think, even over all the others, in that it's automatic. If the offender falls into certain categories, then they don't have to go to court. In some states, you have to file a separate civil lawsuit to get your record sealed, which means the cost of hiring an attorney, court fees, and so forth. So it's unavailable, essentially, to people that don't have those resources. Now, certainly, we also recommend expanding the use of pretrial diversion, particularly in low-level drug possession cases, for first-time offenders especially, so there's no criminal record to begin with. Now, then on the other end of the spectrum, there's some people that aren't going to be eligible for record sealing, and certificates of rehabilitation are used in states like New York and Ohio, and we kind of wondered whether this was really effective in increasing employment. There's actually a study that came out in 2016 that found it did lead to a marked employment. And in some states like Ohio, if you have a certificate of rehabilitation, the employer cannot be sued for negligent hiring if they hire you. And that's actually one of the other recommendations we have, is to immunize employers from being sued for negligent hiring in most instances. And then in Texas, we additionally passed legislation immunizing landlords from being sued simply for renting to ex-offenders. So that's very important as well. Occupational licensing is another area that we are very focused on. One of the solutions which we've adopted in Texas, and it's also a model bill that I've passed through the American Legislative Exchange Council, would allow ex-offenders to obtain a provisional or probationary occupational license, provided they meet all the other qualifications. And basically the way it works is if they comply with all the rules of the occupation, don't commit any new criminal offenses, then after a certain period of time, such as 6 months, it would automatically become a permanent occupational license. So that is a very good thing. Also, declaratory orders to find out in advance from the occupational licensing agency before going to a training program or college whether they would qualify is something that can save people a lot of wasted energy. Now, another collateral consequence is driver license suspensions. This obviously is a federal law which says states have to affirmatively opt out if they don't want to suspend driver's licenses for drug convictions. We also have a huge problem of, we discussed this at the last hearing, people who failed to pay fines and fees. So for example, in Virginia, there are 600,000 people who have their driver's license suspended simply because they can't pay fines or fees. And our view is that people should not have their driver's license suspended unless they're unsafe to drive, which would be indicated by things like DWIs and so forth. So this area needs to be totally overhauled. Now, with regard to access to public benefits, conservatives and liberals, we often disagree a bit on the extent to which we should have certain public benefits. But one of the issues we're focusing on in Texas this legislative session is a bill that's already passed the House that deals with the Medicaid and disability benefits of people being discharged from county jail. And the problem is in most states, you're terminated. So once you get out of county jail, even if you've only been there for a short period, if the sheriff has submitted your name to the Social Security Administration, he gets a bounty for doing that, by the way, your benefits are suspended. And so we know people, 20% of people in county jails are on psychotropic medications. They're severely mentally ill. And then you also have now all these advances in, for example, medication-assisted treatment for addiction, for opiates. And so those are actually covered by Medicaid as well as private insurance. So if we can create this continuity of care for people that are already eligible as they're getting out of jail, we can really reduce recidivism. Finally, I just wanted to address the issue of offender registries. We are working to try to particularly reduce or eliminate children who are included in sex offender registries, those who are adjudicated as juveniles. The R Street Institute did an excellent cost-benefit analysis, and it basically showed the costs of including children in sex offender registries far outweigh the benefits. There's a huge reduction in long-term earnings, virtually no public safety benefit. We're also seeing proposals to create new registries in different states, animal cruelty registries and such, for all sorts of other offenders. And we think legislators need to be very very cautious on this because there's a lot of evidence that the sex offender registry, for example, has gone way beyond what was originally intended in terms of adult sexual predators. And as it relates to children and consensual conduct, it's actually done more harm than good. So we need to be very cautious in adding on new collateral consequences like registries. Thank you.
Thanks very much, Mr. Levin, and to each of the panelists. And I'll now open it for questions from my fellow commissioners. Hearing nobody jumping in, I will jump in. Okay. I have a couple follow-ups. Ms. Walls, in your statement, you included information about some pilot programs in New York, Chicago, California, showing that some family members who have prior convictions have been allowed to participate in public housing together, and that allows access to support services, and they have been successful. You mentioned that some of the, this is a quote from you, some of the PHAs have even found that these programs have actually helped to reduce recidivism in their communities. I'd love to see some sites for that or some more information that follows up about that. Those are exciting programs. And if you have information you could share now, that'd be terrific.
Some of it is in our written testimony. Many of the pilots are being studied, and so they are actually looking at the recidivism rates as they're tracking the program participants. But the one that I noted in my oral presentation is out of Pennsylvania, where the recidivism rate for program participants was reduced by more than 30% as opposed to the average for that county. So I think it definitely does show that there's a correlation between providing stable housing and, importantly, reuniting with their families, with their support network. And so I think if you're prioritizing that, and I think increasingly PHAs recognize the value in doing these programs, that's a benefit to everyone in the community. But what we've highlighted are a few examples. You know, there are more than 3,000 public housing authorities in the country. I think more than 2,500 project-based Section 8 owners in the country. So there's a lot more that has to be done beyond the pilots to make this part of national housing policy.
And I took the point from Ms. Hirsch, having been in the Legal Services Corporation organization before coming to government myself, that that would be very challenging for legal services organizations to be able to represent the full scope of need. Is it your view that, or I guess I should ask, what is your view about a more systemic reform related to housing access?
I think systemic reform has to come from HUD. At this point, project owners and housing authorities still maintain their discretion to deny admission on the basis of criminal activity and a history of criminal activity. HUD has constrained that over the last year, and we're appreciative of that, but more has to be done to push PHAs so that they have actual formal written policies allowing people to reintegrate into society and to reunite with their families.
Can I also comment?
Sure.
One of the issues we've noticed is various city zoning laws relating to halfway houses as well. In Texas and other states, even if someone's approved for parole, if they don't have a valid housing plan, they can't be released. So they might end up serving for, in some cases, 6 months, a year more, even after they've been approved for parole. So, of course, it's not surprising. It's kind of a race to the bottom. A lot of cities don't want these folks coming back to their communities, so they've adopted zoning rules that essentially preclude halfway houses, 2 or more, 3 or more people with a criminal record or who are discharged from prison from living under one roof. So this is something that needs to be addressed, I think, on a statewide basis, certainly, because otherwise there's just a tendency of some communities to try to dump their returning people on others.
I take it, Ms. Walls, that that's also your view that HUD can be responsive to those kinds of concerns as well. Is that right? With some
HUD has
guidance?
an opportunity to be responsive to that. It's also, in addition to the zoning laws, that local governments are enacting crime-free rental property ordinances or nuisance ordinances that are directly targeted towards persons who have been involved in the criminal justice system. They're forcing landlords as a condition of leasing property in that community to do an aggressive criminal background check. They're telling property owners, if you fail to do this or you rent to people with criminal histories, we will revoke your rental property license. HUD took some important steps over the last year to say that this could constitute discrimination under the Federal Fair Housing Act. More needs to be done, however, to regulate and to limit the scope of these laws.
Great, thank you. Commissioner Narasaki.
Thank you, Madam Chair. Mr. Emsalem, I want to say that I think the commission and our staff are in full agreement that we would really like to be able to have more voices, particularly the voices of people directly engaged. We have very limited resources, or we would have had like a 3-day hearing on this. But there is an opportunity, because our record is open for 30 days, to please encourage the stakeholders that you know to submit comments. We'd like to hear about the impact on people with disabilities, for example. We weren't able to work that in. Immigrants, of course, become vulnerable to deportation. We weren't even able to include that in the coverage of this hearing. So really invite you to think about inviting people to submit written testimony. We do pay attention to that. So I wanted to give you an opportunity because you ran out of time and you were about to tell us about positive models for dealing with occupational licensing.
Thank you for those comments, and we'll be sure to spread the word. I'm sure other folks on the panel will do the same. So I just want to mention, you asked about a model to address, and Mark mentioned the provisional licensing model. There's a law in the books, federal law in the books, that was enacted after 9/11 when Congress imposed background checks on all the nation's port workers. Everybody who stepped foot on a port, so people who were currently employed, had really good jobs, had to undergo an FBI background check. And if they had a felony, they would be considered disqualified from working at the port. That's 2 million workers. There was an effort to include some basic worker protections in there that really prove their weight in gold, ultimately. The protections require that they can only look back 7 years for a felony, consistent with the research that Mark mentioned, the redemption research. Folks are no more likely to get in trouble if they stay clear of the law after 7 years than anybody in the general population. So there's that time limitation. It was limited to felonies. They eliminated drug offenses as a drug possession, felony drug possession as a crime. Obviously, that impacts a lot of people of color. So that was another smart move. And probably most importantly, they provided for an appeal and waiver protection. The appeal protection said that you can challenge inaccurate records, which we did a study documenting that there are 17 million FBI background checks conducted for employment every year. Half of those are inaccurate. So that was a big deal for these folks who are trying to keep their jobs in the ports. And then they included a waiver protection which says, here's the disqualifying offense, whatever it is. We will waive that disqualifying offense if you can produce evidence of rehabilitation. So what happened? We represented 500 of those workers through the appeal process to get a feel for whether this was really going to make a difference. TSA granted 97% of the appeals, which goes to show how often those FBI records are inaccurate. That helped 57,000 workers going back several years now, probably more now. They granted 87% of their waivers based on evidence of rehabilitation, which helped another 15,000 people save their jobs. And then the last slide, you can just go to the last slide. Disproportionately, those folks were people of color. On the left side there, you see African Americans benefited. 54% of folks who benefited from the waiver from the waiver were African American. 41% who benefited from the appeal process, the inaccurate records, were African American. So I'm just trying to put in a plug for the impact of some basic protections that we already know about that could be included both in federal law, but also more so in state laws.
Yeah, actually, if I could add, there's a big problem of inaccurate background check information, and we passed some laws in Texas and have another one pending this session, but you get names that are transposed. There's more than one David Smith with the same birth date. And so what we think is important is to make sure that there's a legal obligation on the part of these background check companies to update their records regularly, penalties if they don't, including not being able to purchase them anymore, but also keeping a log of who they sold them to. Because once the genie's out of the bottle, you know, you can have another company in the Cayman Islands who bought them from this company, and how do you keep figuring out who else has those records and whether they're updating them or not? So that chain of custody has to be clear.
Thanks. That's very helpful. I'd like to dig in a little bit to the look back, because one of the things I've been challenged with is, so people are saying, oh, look back 7 years, 5 years, but then you hear the recidivism rate, you know, for the first year, second year, third year is high, but there's a tie between your ability to get housing and a job and your likeliness of having to commit another crime. I mean, some people would commit them anyways, but I think others may be forced into it by circumstances beyond necessarily their total control. And so how do you address that issue? And also, what do you say to people who, I have to say, I'm not quite clear on why we have a ban on TANF recipients. I don't know if it was, I don't know what the debate was at the time. Was it, people were concerned that we're subsidizing drug use? What was it, and what would you respond to them now about whether it still makes sense to have that kind of ban?
Sure, there was actually next to no debate. I went back and checked the congressional record. I don't remember, because I looked a while ago, whether it was 1 minute per side or 2 minutes per side in the Senate on this specific amendment, and there was no debate in the House. So there was very little in terms of a record on what the thought process was. My guess personally was it's the soundbite of no food stamps for drug felons, that sort of thing.
Tough on crime.
Tough on crime. I don't think anybody thought through carefully what the impact was. When you look at TANF, over 90% of the adults who get TANF are women. In order to get TANF, you have to either be pregnant or the custodial parent or other close relative of minor kids. It's not the sort of, drug lord kind of situation. And what you get with those benefits is minuscule. So in Pennsylvania, for example, there's been no increase in what you get as a TANF grant since January 1st, 1990. And the maximum grant for a mother and child is $316 a month. And there are 21 states that are less generous than Pennsylvania. But the difference between having that $316 and having nothing is a world. I mean, it means that you may be able to double up with family or friends because you have a little something you can bring to the table. It means that if you're eligible for transitional housing, you can get it because you have to have some income to get in the door. It's just incredibly huge, the impact of that miserable pittance. The response I would make, and the conversation I've had with lots of very conservative folks, is that it had unintended counterproductive consequences. We spent 7 years in Pennsylvania getting the ban lifted in Pennsylvania, and a really strong ally in that process was the Pennsylvania District Attorneys Association. Our prime sponsor in the Pennsylvania Senate was a Republican former prosecutor who said, I put people in jail, I have a responsibility to think about what happens to them when they come out. And there was tremendous broad-based support once people understood who the population was and what the circumstances are, and just how much it costs to keep a kid in foster care and a parent in jail compared to TANF.
I just wanted to make sure I'm clear. I take it that based on your expertise. Now, can you hear me? I take it based on your expertise and the work that you've done with the women in your community and also the research that you've done, that it's your view that the exclusion of this category of women from eligibility for TANF is a federal communication of animus about which women are eligible and which women are not. Is that correct?
Yes, absolutely.
Thank you. I think Commissioner Fad, you had some questions.
Thank you, Madam Chair. I would like if each one, well, Mr. Levin, who has been here before, I was wondering if I could start with you. Could you submit a packet of what you would consider model legislation for each item that you spoke about?
Yes, and thankfully we have, again, it's these ALEC model bills, the liability one, the provisional licensing, and I can give you the Texas bill on liability for landlords and our non-disclosure, which we have also an ALEC one that just focuses on drug offenders for non-disclosure. The Texas law is broader than that. So yes, I can be glad to do that.
And could you explain, while I have you here, exactly how does the immunization of employers and rental housing work?
Well, basically what the bill says in Texas and Louisiana and Ohio also have the employer ones. I'm not aware of another one on the landlords. But the employer one says there's certain exceptions, like sex offenders, they end up being exempted from most bills to pass them. But, you know, that for most offenses and offenders, that an employer cannot be sued simply for the fact that they hired someone who has a criminal record. And so if they later did something, you know, that obviously caused a problem, it would be an immunity that the case would have to be dismissed. And then similarly for the landlords, it basically says with those exemptions like sex offenders, they can't be sued if something happens at the complex, apartment complex, relating to that ex-offender, simply on the fact that now the employer could still be sued for negligent supervision. You might have a duty if you hired somebody who, you know, was a thief, right, to make sure they didn't steal from your client or something, right? But that just the negligent hiring part, they're immune from.
And you can send us copies of those statutes as well.
Yes. And I also recommend there's a Minnesota statute, which I think is very good on the licensing issue, because it says there's a lot of states that say it has to be related to the occupation to disqualify. But these occupational licensing boards, the people on them are in that occupation. They look for any way to say it's related to keep people out and reduce competition. Now, the Minnesota provision says by virtue of the person being in the occupation, it has to be the case that it would be more likely they would recidivate, or if they did recidivate, it would cause particular damage by virtue of them being in the occupation. So you think of course, as a child sex offender working in the child care, having a licensed child care. Obviously, we don't want that. But it's very few. And of course, you don't want somebody guilty of insurance fraud selling insurance. So those are the things where the person would be put in a position to do more damage by virtue of having that license. That in some ways is really nails it down, I think.
Thank you. And Ms. Hirsch, I would take it that you would want the restriction on TANF and food stamps lifted. Do you have any other items that you would like to see done in that regard, in those regards, or other regards?
Yes, actually. I would very much like to see that provision lifted from federal law. There's also a complicated set of provisions that we have a chart that I did for Pennsylvania laying out each of the public benefits programs and various different criminal record possibilities and what the implications are. And so I focused for today on the TANF and food stamp ban, but there's a complicated patchwork affecting with other provisions affecting food stamps, not affecting federally funded Medicaid, but affecting state-funded medical assistance. And there are also provisions affecting supplemental security income, SSI, benefits from the Social Security Administration.
Right. I think that was mentioned by Mr. Levin. What kind of recommendation would you have, or Mr. Levin? I'm sure he has a recommendation. He has a recommendation for everything. What kind of recommendation would you make regarding the Social Security disability cutoff, or actually Social Security disability? They also cut that off as well when you're in jail.
Right. They have different provisions for each of those programs. One of the very harmful things that occurs with SSI is that your benefits get suspended once you've been incarcerated, plus Medicaid. And if I could say something about Medicaid in a minute. On SSI, though, your benefits are suspended while you're incarcerated. But if you're incarcerated for 12 months or more, your benefits are not reinstated when you get back out. And you have to start from scratch proving the same disability that you had at the point at which you became incarcerated. And that reapplication process can take years, literally. So even if benefits continued to be suspended while you were incarcerated, if they just could get reinstated at the time of release without having to reprove disability. And that's currently the law for Social Security disability benefits, but not for SSI. So that one piece would be huge. Concerning Medicaid, as Mark said, there's an option under federal law for states to suspend Medicaid, when someone is incarcerated, and then to reinstate it, just turning it back on without requiring a whole reapplication process when they're released. That's a great idea. Some states have done that and have done it really well. Other states are currently in the process of looking at it, and I just want to add a cautionary note, because if it's not done properly, it can do more harm than good. So a state that's currently considering it, I don't want to name the state because we're in conversations about doing it right, but the initial plan by well-meaning people was to suspend Medicaid as soon as they learned someone was incarcerated without waiting any period of time. So for folks who are in county jails who get arrested and make bail, very quickly get released, there would be this computer exchange of data that would mean their Medicaid would have been stopped. And the state then acts on any information for any other benefits the person may be receiving. So it would mean that their food stamps, or if it was a parent with minor kids who was getting TANF, their TANF would be terminated because those programs don't currently have a provision for suspension. And in addition, this proposal, this plan, involved cutting off the benefits for the kids. So mom or dad gets arrested, the very first thing the state is going to do is take away food, medical care, and shelter from the kids, because it wasn't well thought through. There are states that have done a really good job on this. New York State, I can't remember if it's North or South Carolina, checks with the family to find out who's got the kids. Does somebody else have the kids who needs the benefits? Can we get those benefits transferred to the person who's caring for the children, as opposed to just cutting them off? So that Medicaid suspension idea is a great idea, but the devil is always in the details and how it gets.
Can you send us your Pennsylvania chart?
Yes.
Okay. Thank you.
Happily.
Ms. Waltz, I'm working my way down to mine, Madam Chair. I just thought I would cover it so that my colleagues could rest and relax this afternoon. Thank you, Commissioner Cruz.
But you have Commissioner Yaki in the queue waiting for you. So.
Okay. Ms. Waltz, you were regarding housing.
Yes.
And your recommendations, do you have any model recommendations?
I do. We can provide copies of legislation that we think is helpful that state and local governments can pass, as well as some of the model reentry pilots of housing authorities around the country. Happy to provide that. In terms of a recommendation, as I said, I think it's important for there to be a limit on the discretion provided to public housing authorities and project-based Section 8 owners. I think at this point, even with the guidance from HUD as to the Fair Housing Act and the PIH notice, they retain the ability to still look at almost any conviction. They retain the ability to define what a reasonable look-back period is. And just to pick up on a question that was raised previously, I think it is different in looking at a look-back period for housing versus employment. In the HUD PIH guidance from 2015, they suggest as one example of a housing authority, a 24-month look-back period for violent criminal activity and 12-month look-back period for drug-related criminal activity. Importantly, what we want housing providers to do, and I think what the Fair Housing Act requires them to do, is an individualized assessment. They have to remove from their policies the type of blanket bans that we have seen for so long. They have to evaluate the individual if they have rehabilitated themselves, and if bringing them back to the community will reunite the family and not harm the community in that process.
Let me ask you this. This may be my informational question, but if you were a landlord and somebody came to rent to you and they had just gotten out of prison and they were a meth manufacturer, and when you get busted for manufacturing meth in your bathtub, then you need to do a hazmat, a whole thing. How would you handle that?
Well, as I said,
I think it's a practical problem.
It is a practical problem. So I'll say this. If you are convicted of manufacturing methamphetamines in federally assisted housing, there's a lifetime ban. It's mandatory.
But you want to change that.
Well, no, we are actually not talking about lifting the mandatory lifetime bans. We are talking about everything else. So there are the 2 bans for the manufacturing of methamphetamines in federally assisted housing and a person on the lifetime sex offender registry, though I agree with the concerns about the overreach of who is on the registry. Our primary concern, however, is that all other types of criminal backgrounds, whether or not you are admitted or that is considered, is left entirely to the discretion of housing providers. And that's where we need to rein it in and ensure, because not all criminal convictions or histories are the same.
Thank you. Madam Chair, may I just ask Mr. Islam
Proceed.
my last,
Yes.
And your recommendations, sir? Do you have written recommendations, models, things like that that you can submit?
Yes, yeah, we have a couple publications. We have a recent report on occupational licensing called Untapped and Unlicensed, and which has model legislation, all the good stuff that's been mentioned on the panel is in there. I would just put in a plug. We're real interested in trying to move federal legislation in this area as well. The Obama administration directed all federal agencies to look at all the collateral consequences in federal laws regulating employment. That level of transparency is really important, and we have to get to that point, collecting the data, understanding more of the impact. So I would just put in a plug for that. And we also have model legislation around fair chance hiring and other issues. So that's for sure, we can pass that along.
Commissioner Yaki, I understand you had a question?
I fell asleep. No, just.
Sorry, Commissioner. Oh,
There you go. Thank you very much, Madam Chair. Following up on my colleagues' calls for model legislation, part of me, I discussed this during the break with Ms. Walls, is that sometimes I think a lot of these, part of me as a former policymaker goes back and thinks that some of these restrictions or bans were in some way a part of gating control for the fact that most of these programs are pretty strictly rationed in terms of how much money there is available. Because if you think about it, they're supposed to be enacted as a deterrent, but if no one knows about it, how can it be a deterrent? And it's really just more punishment when on the end. The question, I really don't have a question so much as just asking for your comments on this, which is, what Commissioner Clanny is gathering together, I presume is to provide part of our recommendations going forward. But to what extent can there be sort of one big federal type bill, and what would it be able to accomplish going forward? Because when we think about this, and this dovetails on everything we've talked about early in the day, there's essentially an ecosystem here of how does someone get out of the recidivism trap? How does someone make it back as a productive member of society? So it's not just a job, it's also what kind of job that goes in the licensing thing. It's where do they go to stay after their job. It's whether or not if they come out and they have small kids, do they get WIC, do they get TANF? All these things that go together, provided the things that we all take for granted that are out there, but which are all singularly regulated in one way or another by different programs. Is there an ability to have sort of comprehensive federal legislation that would either set a model for all the states, but also get rid of, in one fell swoop, sort of all the things that are out there in the federal government, at least, so that we show what it is that we can do to address the collateral consequence dilemma?
Yeah, I'll just start at a couple places. I'm sure everybody else has a bunch of ideas. I mean, part of it's just repealing all the bad stuff that was around before, the SNAP and TANF restrictions, the Pell Grant restrictions. I mean, that's a matter of just repealing those limitations. That would help a lot of people. I think on the housing and employment side, for sure, on the employment side, we really want to make sure that this idea of individual assessment, blanket restrictions against hiring folks, we're not taking away the discretion of employers or housing providers. We just want to make sure there's a fair process. So incorporating those principles into federal law, we have it now, we have good guidance and all that, but to really make it, to put teeth into the process, those sorts of protections would be helpful. And I'll just throw in, there are a couple bills on the Hill right now, one that would clean up the FBI background checks for employment, which is really important, and we have a direct federal ability to do that. We don't have to tell the states how to clean up their records. We have our own records. The feds have their own records that would make a big difference. I don't know if that is a, gets everything in there, but there's a lot of opportunity to do that, I think.
And,
Go ahead.
Oh, well, there's the REDEEM Act that Senator Rand Paul and others have that would certainly help as far as the record sealing goes. Also, with all these collateral consequences, a lot of states have a sunset process, so you could put a sunset date that they automatically go away unless they're renewed, and that's, I think, a great idea for a lot of laws. But I'm glad you also brought up the kind of work, because there was actually a specific study that showed that when people are in skilled, often licensed work, there's a further 11% reduction in recidivism over just being employed in food service, for example, the low skilled work. So that's very important.
I think it's what I was talking to you about on the break in terms of the effect one-strike laws have had on federal housing policy. Those were passed in the 1990s with the intention of going after serious criminal activity that was a problem for public housing authorities in particular. It has been extended to be any contact with the criminal justice system whatsoever. I've seen in my own practice where children who should have their records protected as confidential in Illinois, having their families be at risk for losing their housing because a child has been adjudicated as delinquent under the Juvenile Court Act, right? And so if a mother is saying, you have to leave my home, and the child's 14 years old, right? And you are permanently setting that child on a negative path. And so the laws have went too far. They permeated into the private market where private property owners and local governments say, we need one strike, we need to get rid of all crime. And so if we start by repealing those laws, that may have an impact on what's happening at the private level as well. And bring some reason and humanity to this process. It allows people to reintegrate into society.
Great, then I will come back to Mr. Emslem with another question, if you don't mind. Your materials talk about the benefit of the EEOC guidance, and I'm a little confused. You said at one point that nearly 90% of employers conduct criminal background checks for employment, which then suggests that the 2012 EEOC guidance hasn't been as effective as we would like if they're continuing to conduct these background checks. And then later, you cited really hopeful statistics saying that there's a very high percentage of employers who report complying with the EEOC guidance.
Right.
So I'm trying to figure out where benefit lies in the guidance itself, and then what, in addition, you think might be a useful federal step.
Right. So, hopefully those are not inconsistent. I mean, the fact that we have a lot of employers who are still conducting background checks doesn't mean that they're not applying the EEOC standards in doing so. So that's really the difference, right? So, I mean, there's a lot of commercial data brokers out there really pushing background checks. It's a big profitable industry. And then there's a lot of the talk around negligent hiring, which actually is, not all that accurate when it comes to the reality of how many folks are actually sued or held liable for negligent hiring. There's all that kind of, a little.
So can I pause for a second just to make sure I understand?
Yeah.
Is it that they're conducting the background check, but at a different point in the process, which is what you had said you had hoped for, or is it, we don't know?
No, so they're conducting the background check, but according to these employers, so everybody's conducting background checks, mostly bigger employers, less some of the smaller employers, but they're conducting the background checks consistent with the EEOC guidelines. They're considering the age of the offense, the nature of the offense, the individual assessment process. Again, which is about not removing the discretion from employers to decide who they want to hire, just applying these kind of more fair criteria.
Okay, and so then is it your view that the EEOC guidance from 2012 is a sufficient federal step, or there's something more?
Yeah, no, I think it's a huge federal step, and again, we need more enforcement resources. And they did a great job when that guidance came out. They did a great job publicizing it. There was some pushback from employers, but I think over these last couple of years, really, they've been very comfortable with the guidance. That's reflected in these surveys. So now it's really about trying to enforce the law, which is true of any labor law in the books. It's like it all comes down to enforcement, and they need those resources to do that.
Right. Thank you. Mr. Levin, you look like you had something to say?
No, well, one interesting area that's kind of emerging is healthcare workers, which we might look at, because I know in Texas we have a statute that's, if you had virtually any convictions, you can't, that's accepted from all these other good bills I've been talking about. So I think the aging of our society that I alluded to earlier, I mean, obviously you don't want elderly people in a vulnerable position being taken advantage of. So it is a delicate balance. So that's, well, no, you're not elderly.
So on the healthcare issue, I mean, there's a federal initiative, I think the HHS folks are here actually, where they're promoting employment because it's such a big demand industry. They're promoting employment of folks with records in the healthcare industry. We received some funding from JP Morgan Chase to hold forums around the country. We held 3 forums in different cities. And we have an employer guide that's all about promoting employment in the healthcare industry. So Mark's right. I mean, we really want to pay attention to these growing industries. I would put transportation in that bucket as well, childcare, where we know that, you know, there's a huge demand for the workers. Some of them are really good jobs, and we want to make sure that those jobs in particular are not leaving people out.
Thank you. I want to make sure that we hear from the Vice Chair if she has questions for this panel.
I do not, Madam Chair.
Terrific, thank you. Any further questions from my fellow commissioners? Commissioner Kursnap?
I just want to note for the record that Commissioner Gladney has a surprising amount of information related to the manufacture of methamphetamines.
We're going to not comment at all. Commissioner Osaki.
He is from Nevada. No, so I had a question. We had earlier discussions about the impact of the insurance industry. We talked about it mainly in the employment context earlier, and I wanted to ask about it in the housing context, because I understand from the written testimony that there is a role that the insurance companies play in terms of causing landlords to be more restrictive than they might otherwise have been. And I wanted to get a sense from you of how would we address that?
I don't believe that was from our written testimony, and I didn't hear the written testimony prior in terms of the insurance industry. We have certainly seen the insurance industry pose limitations on who property owners can rent to. They may say you cannot rent to Section 8 voucher holders. They may be asking for other screening requirements. In our experience, the bigger concern nationally has been local governments requiring private property owners of all size to conduct a mandatory criminal background check and to commit not to rent to an individual if they somehow fail that test, so they don't define what that background check is. And so out of an abundance of caution, so they don't lose their profession, right, and their ability to be a property owner in that town, they will exclude anyone who's had any contact with the criminal justice system whatsoever. And so landlords and realtors who are not always ally with tenant advocates actually are somewhat aligned on this issue, that they have lost their ability to look a tenant in the eye and determine if they will be open to renting to them, even if they have a criminal record.
So in that circumstance, though, what could the federal government do?
It may be, and there was a notice issued by HUD's Office of Fair Housing and Equal Opportunity last year that spoke to concerns over the proliferation of crime-free and rental property ordinances, nuisance property ordinances, and said that these laws could violate federal fair housing laws. The focus of that guidance, however, was the impact these ordinances have on victims of domestic violence and sexual assault. There was a brief recognition of the impact they may also have on individuals with criminal records. I think more guidance could be brought on that issue. I think there also could be opportunities to provide funds in terms of testing, where we're identifying that oftentimes the criminal records screening is actually a proxy for race discrimination. I think HUD could provide that funding to FIPS and other fair housing organizations. And I think local governments have to be discouraged from enacting these laws, particularly if they are recipients of CDBG, home, or other housing and community development funds, that if they are using those federal dollars, which require them to affirmably further fair housing, they must, at a minimum, evaluate the impact that type of ordinance may have on protected classes, including individuals with criminal records.
But what is the incentive for cities to be developing in this way? I mean, what's causing them to have such strict requirements?
There was, out of Mesa, Arizona, there's a National Crime-Free Institute. And so they were pushing out local governments coming to their conference and talking about this was the way to reduce crime in your community. And so we saw local sheriffs in Illinois and police officers come back from these conferences and believe that this was the way that they were going to reduce crime in their communities. In reality, when you look at the jurisdictions that have passed the laws, they will say that they've had an increase in crime. What they've actually had is a change in their racial demographics. And so they believe that crime is going to come based upon a stereotype and some degree of bias. And so the majority of those new home individuals may be renters and persons of color, and they believe they need to regulate that market. And so you see then the passage of these crime-free and nuisance property ordinances and this aggressive screening criteria. And even where there is crime among homeowners, you don't see those policies applied to the homeowners. You see it exclusively applied to the renter populations.
Thank you. That was very helpful.
Commissioner Degmiller?
Ms. Walsh, one practical question. With respect to the PHAs, is there a process that you suggest through which they could conduct the type of analysis that you think is more fair? And the reason I'm asking this is a very pragmatic concern. I represent a PHA, and so I have some understanding that there are some structural underfunding concerns from the federal government. And so I'm just wondering whether or not they have the wherewithal to do the type of analysis that we may want them to do in the perfect world. And if not, are there any creative ideas out there, tools that could be given, pilot programs about how this analysis can be done in a way that sort of meets the goal of trying to reunite families? I'm making that disclosure, but I think it's germane to the inquiry.
I'm happy to offer free legal advice.
And I don't represent them on this for this purpose.
The Housing Authority of New Orleans, I think, has a terrific model that other housing authorities of all sizes could potentially replicate. They are doing the individualized assessments of an individual who has a criminal record. Certain criminal histories are not being considered at all. So that person can be potentially eligible for housing irrespective of their history. If they don't meet those exceptions, then there's a 3-person panel that will meet with them and do that type of individualized assessment and give them an opportunity to show that they should be eligible for this housing, that they've shown that they do have evidence of rehabilitation. So that type of forward thinking, I think many housing authorities can adopt. When we talk to housing authority directors, they want to do this. They hear directly from families who are disconnected from their loved ones. It's also a safety issue for housing authorities, I would submit, that there are many individuals who are living in the shadows in subsidized housing in the United States, and they are not on the lease because they can't get on the lease, or they perceive that they can't get on the lease due to these policies. And so if the housing authority and project owners are saying, here is an opportunity for you to come forward based upon certain conditions, whether it's the New York model where there's support services that are brought in and they are there on a temporary basis until they complete the program, or the Housing Authority of New Orleans model where it's forward thinking in terms of trying to get you in at the front end to reunite with your family. But I think that actually assists the housing authority in addressing, which I think is a fairly common problem of unauthorized guests on their properties.
Thank you.
It might be interesting to look at also if there's something similar to what we have on the employment side, which is there's a federal bonding program, and the workforce agencies in each state can tap into that. So in other words, if something happens after that employer has hired somebody through which there's been a bond issued under this program, then that covers whatever the cost would be. And so it's kind of like almost like a reinsurance or backup in case something arises.
Commissioner Narasaki?
Thank you. I have one last question. There was some discussion this morning, there's some discussion in the testimony about the Fair Credit Reporting Act and how it could be used to clean up some of the data that is out there. So there's offerings of saying, well, FTC and CFPB should do more enforcement, but not exactly what kind of enforcement would be helpful and why aren't they doing it now?
Yeah, I could speak a little bit to that. I think what's needed, you know, like I was saying before, it's a huge industry, the background check industry, and a very profitable industry. So, you know, it's hard to regulate an industry that big. So I think what's needed is definitely some enforcement resources, and CFPB was starting to do more of that, but also some targeted audits. I think, and they have some authority to do that, and some new regulations. You know, obviously in this environment, it's hard to get a lot of this stuff on the books, but that's the sort of thing. Targeted auditing is very common in other areas where you know there's a problem, you've picked up on a problem in a certain area, and then the agency has the authority to go in and ask a lot of questions about what's going on with that particular background check company. And then you've got a lot of new products that keep coming down the pike that are not just standard background checks, but like there's a whole new product around retail. If you've ever had a problem working for a retail employer, now you end up in a database. Well, that's another form of background check. So kind of getting on top of these sort of deregulated industries or new industries, that's another important feature of it. But yeah, the FCRA is a huge component of what we're talking about here.
Thanks, very, very helpful.
Well, thank you. Let me ask again, any further questions? Hearing none. Thank you very much for this panel, and again, for a really informative panel and for the work that you've done that led up to it, and really look forward to the follow-up information that you have promised to us as well. Thank you. Before we end this portion of our day and the briefing, I want to say again that the record for this briefing will remain open for 30 days, and we really invite further presentations, further information to us. It's very helpful to us as the staff at the Commission generate the reports, the report that will follow from this, and also as each of the commissioners generates our statements. So if panelists or members of the public would like to submit materials, they can mail them to U.S. Commission on Civil Rights, Office of General Counsel. The address is 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C. 20425, and by email to reentry@usccr.gov. So with that, I thank the panelists, I thank our audience, and we will take a 15-minute break before proceeding with our business portion of the meeting. Thank you.
Thank you.